Privilege. What does this word mean? Well, it's defined as a special advantage, immunity, permission, right, or benefit granted to or enjoyed by an individual or class. Such an advantage, immunity, or right held as a prerogative of status or rank and exercised to the exclusion or detriment of others. Now let's look at privilege through the lens of the Canadian Constitution and the Charter of Rights and Freedoms. Section 15, Equality Rights. Equality before and under law and equal protection and benefit of law. Section 15, 1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Okay, so ultimately, this section has been created to equalize the level of privilege that any group within our society may have, or may be entitled to, or may try and lay claim to. That seems fair enough. Let's move to the next section below it, the affirmative action programs, subsection 2. So it says, subsection 1, paragraph above, does not preclude any law, program, or activity that has its object I always have a problem with this word, that has its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Okay, so what exactly does this section mean exactly? How does this change the first section? Well, ultimately what this does is it leaves it open for the courts and special interest groups, in particular the special interest groups who create programs or activities to fight for the rights or to claim for special rights for any of these groups. So what this means is when this was created, it left it open for special interest groups to litigate using this section of our Charter of Rights and Freedoms and Constitution. They're both one in and of the same. Quick little history. The feminist and women's rights groups actually fought to create this and have these sections added to the Charter of Rights and Freedoms. As you can see, little footnote number 84. This basically took effect in 1982 and 1985. Well, it was created in 1982 and took effect in 1985. And this was the same year that the Constitution and the Charter of Rights and Freedoms were blended together as one doctrine for our country. So for those who are unaware, this was largely a project of women's rights groups to get this installed. So ultimately all it did, it doesn't outright proclaim here that any group has a special class or has special equality rights. What it does is it generally declare, and this is my interpretation, it generally declares that there are disadvantaged groups that can be of a different race, ethnic origin, color, religion, sex, age, whatever. So there are disadvantaged groups within our society, and we leave it open to the courts to allow us to use litigation to determine who those disadvantaged groups are. And with each case that we litigate and set precedent with, everything follows. Everything is dictated by those precedents following the litigation. So, and as you can see, section 28 below, notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. This was also added by the women's groups, sort of as a, yes, we want to determine who all the disadvantaged groups are. However, to try and keep it fair, we will still proclaim that equal rights are applicable to male and female persons. So that's kind of weird sticking that section in there, like we're leaving privilege open to determination by the courts. However, we still proclaim that male and female persons are equally guaranteed. But enough litigation has happened by the feminist groups over the years since this was put into place that have ultimately made it so that the females have more equal rights. The women simply do have not equal rights. They have special rights over anyone that does not belong in any of these disadvantaged groups, which ultimately leaves us with able-bodied, white, straight men. So let's consider the groups that today we consider as disadvantaged. We consider women disadvantaged. We consider the mentally ill disadvantaged. We consider disabled people disadvantaged. And we consider Aboriginals disadvantaged. I'm not 100% sure how many cases have set any precedent for African American people in our society. So I can't really speak to that, but the ones that I did just mention, we all know about because they're always talked about in the media. So let's also look at the fact that the special interest groups that exist today solely litigate for these groups that I just mentioned, Aboriginals, women, and mentally and physically disabled, as well as homosexuals as well. The LGBTQT, although I think T is something we're working on right now. Now, with all of this in mind, consider funding. Funding is the main issue here. As soon as this Constitution was created in the 80s, women's rights groups were institutionalized within our own government under the Ministry of Status of Women. We still have this ministry today. There are groups that have received funding to simply for litigation, and one of them is, the acronym is LEAF, L-E-A-F, and what that stands for is the Women's Legal Education and Action Fund, and they have been at the forefront of litigation. They've litigated for Aboriginal rights, they've litigated for homosexual rights, they've litigated for women's rights, they've also litigated for elderly rights. Now, of course, they've done some really good things. I'm not saying they're a horrible special interest group. What I'm really trying to do is illustrate how we got to where we are today and the fallacy of the straight white male privilege claim that feminists and social justice warriors spout out. Because ultimately, with each case that's litigated, and with each case that determines what a disadvantaged group is in our society, we further eliminate the straight, white, able-bodied male from a place of equality under the law. And that is the reality of where we are today.